Thank you, sir. Good evening, everyone. This is Anika Sharma. I'm your moderator for today's session. I welcome you all on this second day of National Workshop on Memorial Drafting and the Art of Argument. Today, we again have with us Advocate Arish Visruth, who will guide us through this topic, and he has been a part of various moot court competition and has won many, and he has also judged various competitions, not only moot court competitions but client counseling and other competitions as well. And further, he has been a debater and been a part of quiz competitions as well. So he has a great experience of moot courts. So now we have Sir to begin today's session. So please.
Am I audible, Anika? Hello, Anika, can you hear me?
Hello, sir. Am I audible?
Can you hear me clearly?
Hello, am I audible?
I can hear you. I guess I am having some network issues. Can you hear me now?
Hello.
Yes, sir.
Okay. All right.
Am I
If at any
audible?
point of time, if you guys couldn't hear me clearly, please let me know. Okay, so that I can repeat myself. Now, as we have done with the first half of the art of mooting and the memorial preparation, the second leg of the session is supposed to be done on the oral rounds or oral arguments. How to prepare, how to present, and what are the things that you need to take care of, the do's and don'ts, and everything like that. So before I move on to the presentation for the day, let me tell you a couple of things at the beginning itself. The first thing being, see, moot court, it is all about a teamwork. It is all about a teamwork where each and every member of the team is supposed to work hard in a consistent manner. Even if you think that it's like a, compare it to a sprint, it's never going to, let you anywhere near success. It's all like a marathon. Once you start, you need to keep yourself in the track till it is over. You need to keep yourself running. So just like that, each and every member's role, including the researcher and the mooter, everyone's role in moot code is very much important in the total success of the team in winning a competition. So as I told you many things about the memorial preparation yesterday, I think it's time for me to move on to the oral arguments as to how to prepare and what are the things that you need to take care of. Right. So I will just have a couple of slides to present. Then the rest I will talk to you in an interactive manner is what I think will be most suitable for the time being. So you got any queries like yesterday, you can ask it to me via the chat box anytime. So once I'm done with the PPT presentation, I will definitely be answering all those. Okay. So feel free to ask questions because it's the questions that which you ask which is going to let us have a good interactive session for the time being. Yes. So that, is the presentation visible to everyone?
Yes, sir.
So, the art of memorial drafting and skills of arguments in moot court. Now, coming to the moot court oral rounds preparation, we can divide that preparations into three stages. First one, you are basically starting your preparation for oral arguments after being done with your memorial research. Second, You need to know about the structure and sequence in which you are supposed to give a oral round presentation in the code, as in the mood code. And the third deals with the etiquettes and style that you need to take care of while you present, which will definitely help you in attracting more marks from the side of the judges. It's not just about getting marks, but it's also about creating an impression before the judges by, you know, improving your own presentation skills. So to start with the first stage, the preparation for more oral arguments. As I told you yesterday, the importance of the mood proposition or the fact sheet is very much relevant while you prepare the memorial as well as you go for your oral rounds. So when I told you yesterday to identify the keywords while going through the mood proposition, I also told you, if you do remember correctly, that you need to identify the material facts and also segregate it from the immaterial facts in the mood proposition. And by this material fact, what I intended to convey is you need to identify around 3 to 5 key, strong, leading argument points, which is called as the factual argument points. And these 3 to 5 facts should be the main pivotal point upon which your factual argument revolves. And these facts are supposed to take care of your contentions, whether it be from the side of the appellant or from the side of the respondent. So, for that, definitely you need to have an argument notes with you. So, by the transcript, what I meant is the argument notes. So, how to prepare an argument notes is something that you need to know. Most of the students I have seen, most of the mooters, they just follow whatever is written in the memorial. They just read it down right from the memorial. Okay, this is the biggest mistake that you could ever commit, because even though you have already written down every single important point relating to your contention in that memorial, even then, how on earth do you expect yourself to finish all the contentions and also briefing the facts, answering the questions of the judges, referring to some statutes or other documents, compendium, anything that you have to rely upon, and and yet you yet how do you expect yourself to finish within the allotted time? It's not that easily possible, because most of the times when you write down a contention, it goes for pages and pages. Say, for example, if the contention is on Article 32, maintainability, or it's on Article 136, special leave petition. As I mentioned yesterday, in Article 136 special leave petition, there are two criteria to be proven. One, that there occurred a substantial injustice, and second, there was a grave question of law or a substantial question of law to be answered. So in those two conditions, you can take a special leave petition before the Supreme Court, and you need to prove these two grounds before the Supreme Court. Then only the Supreme Court will decide. And even otherwise, even if you prove these grounds, it's upon the complete discretion of the Supreme Court, the apex court, to let your special leave petition stand or to dismiss it. So every single time you argue before this, moot court, you will have to say n number of things to substantiate your contention. So don't rely upon your memorial contention as of written there to finish your arguments, because it's going to eat your time. It's not going to let you finish on time, and you will be left middle in the middle of the road somewhere without even finishing the argument. So in toto, what happens is that leaves a bad impression with the judges. What they get to feel is you are an incapable counsel, not enough, capable enough to protect the interest of the clients. So that shouldn't happen. So you need to have an argument notes which should be quite different from the contentions that you might have written down in the arguments advanced. What you need to do is, say for example, if the first issue is on Article 32 or 136, whatever it be, you need to find out the central theme. The central theme in Article 136 is the special law petition 136. So you need to make a roadmap or a blueprint covering around 2 to 3 points, and you should be able to clearly and straightforwardly chart out the issues that you will be addressing through this particular contention by explaining the blueprint or the roadmap to the judges in the best possible manner. So what is the advantage of this particular point is the judges will get to feel that okay, you are very much clear and having a thorough understanding of what you need from the judges, what you need from the court to do. So that will help you to create a very good impression before the judges. So in order to do that inside the court, you need to be yourself thorough and prepared with that. So once you prepare the transcript, you identify a central theme, you make a blue map, a blueprint or a roadmap with around 2 to 3 points in that. You chart out the issues very clearly and straightforwardly. And over there, what you need to do is you need to hierarchically arrange the arguments in around 2 to 3 levels. As in, the best point, the leading point that you have will be the first level of argument that you will be shooting before the judges. The second thing which will be supplementing to that argument, your leading argument will be the one which will be going second. Likewise, you need to frame a hierarchical order of arguments and then break it down to sub issues. And at the very same time, I'll tell you one thing. Even if you have a main argument notes or a transcript, you need to prepare a supplementary transcript. And through supplementary transcript, what I mean is just like as in the memorial, we used to write the summary of arguments before we start with the arguments advanced. What we do there? We just write down the important points of each and every contention, not in the question way, as it might have been written when you might have wrote the issues raised, but in a sentence format to answer or to lead it to your prayer. So these are the things that you need. But more than having a heading of your contention, it will also have those points which you think is going to be the crux of your argument. So just like that, you need to have a supplementary transcript with you along with your argument notes. The necessity of having such a transcript is, suppose for example you are presenting with the first contention and the judge interferes you in between and he or she keeps on asking you questions and finally you are left with just 1 minute, and that is not to you along with the judges when the court master lets you know that you are left with just 1 minute. So the judge will say, now you can wind up your arguments. We are done with your first arguments. If you got anything to say in your second contention, wind up within just 1 minute. We are not going to give you extra time. So if you have already prepared a transcript and say, for example, it went up on to 1 to 2 pages or something, you can't yourself pay justice to your side by starting with the argument in 1 minute and without letting it finish within that 1 minute. So you need to have a supplementary transcript, which needs to be used at that point of time when you are left with very, very nominal time into your hand and the judge is not going to let you have extra time, but you need to finish 1 or 2 arguments, which you might not have already started with before, no, as a presentation before the court. Now, why I incorporated the point of having a coordination with the researcher? Because most of the teams I have seen, they undermine the value or importance of having a researcher in the team. All because of the reason that they think it's all about the two presenters, the two motors presenting before the judges and that day of presentation. The researcher has got nothing to do unless the researcher got a researcher test. But I disagree with that. I disagree with this particular fact because I am that kind of judge who doesn't even let the researcher sit very calmly over there. I always fire with the researcher also. I always lay down a ground rule once I start the presentation. Before the first word is uttered by the first speaker, I let them know any questions which are not answered by the speakers will have to be written down in answers and handed over to the judges once their presentation round is over for the team. Second, apart from the judge being critical like that, why you need to have a coordination with the researchers if you have a compendium to present. Okay, the researcher need to know when are you going to state which case, which is the order in which you have arranged the cases in your argument, so that he or she will be able to submit it before the courts. Now, for the time being, when you are having these online modes, you might not, might not understand the relevance of having such a particular rapport with the researcher, but it does a great miraculous role in winning a mood. Trust me when I say this. I'm saying this from my personal experience. Since my third year in my college, I always had a single researcher because I never let that person go from my team. That he was the best. And once I got this guy in my team, more than 50% of my headache regarding the whole mood preposition research and also on the day of presentation was over, because I need not worry about anything else. He or she, he will be the one who will be taking care of all the things except for presentation. I just need to think about my presentation. So you need to have a very good connection with the researcher. And along with that, I have seen people having a lot of confidence issues, especially when it comes to having barriers regarding the language. English being the second language, most of them uh, generally fumble before, and they generally wonder why, or where they could what to say, they could, whether they could provide justice to their arguments, whether they will be able to completely finish it on time and all this. But I will say, never worry about this, language barriers and confidence issues, and never let them worry you, because if you practice and keep on practicing, practice by that thing, what I mean is you need to present your transcript before, you know, the maximum number of people you could ever get, face the maximum number of questions from different people, different panels, your seniors, your friends, even your teachers, or even a practicing lawyer whom you might be in, you might have interned with. But learn yourself through practice. You need to present the transcript n number of times, and I guarantee you, your presentation will be directly proportional to the number of times you present. The quality of your presentation will keep on improving, provided you keep on presenting it and keep on practicing it. Because you will learn that there are some mistakes that might have occurred in your argument notes in the transcript that you need to correct. You can refine yourself, and you can need to do this, and it will also help you to realize one more thing, that you need to stick on to the time. If the rules of the Mukut says that each speaker will be given 15 minutes, or the team is in total allotted with 30 minutes, then you will have to divide it maybe like 14 and 2 minutes for rebuttals. Then right from the first day of your practice, don't take more than 14 minutes. If you couldn't completely finish your contentions before that 14 minutes, then it means you need to improve from your side. Now, going to the second thing, the structure and sequence. Here, what I would say is, this thing happens when you go inside the court. Okay. The structure and sequence is all about the day of your presentation, the moment you step into that court and you face the judges. So everything, right from the moment the judges enter the court, right from the moment they see you, everything is important. You should be attentive. The opening, that's what I mean with opening. The opening from your side doesn't start with the first word that you say in the podium. No. It starts from that moment the judges step into the court. Because they will be observing you, the way you sit, the way you dress. If you dress, I have seen people not being that serious, and it shows the seriousness of your preparation when you don't have your, dress code properly maintained, or not maintaining a disciplined outlook inside the court. You just need to remind yourself that you are sitting not just in a moot court hall in some law college, or maybe in your own room when you're doing an online mode, but you are presenting in before the Supreme Court of India or the High Court of that state, or maybe in the case of international moves, it might be the court of ICJ or ICC for that matter. So you need to give that seriousness. You need to let the judge feel that you are completely attentive and is waiting for the judge to hear your case. You shouldn't let any other distraction be on the path, so that the judges will notice it and will result in having discredit for your marks. Now, regarding the introductory statement, it so happens when the team is being called to present, the first speaker steps in, he or she moves to the podium. But I would say, even before moving to the podium, just go before the judge. Just go a little and let them know you respect the court, because this is the normal practice that we have in the courts of India. Every time you enter a court, you go before the judge. You at least, fold your hands. In some courts, it's just practice like folding the hands before the judge. Or in some courts, they even practice the habit of bowing before the judge. So in moot courts, the standard practice is bowing before the judge. Before you even approach the podium. After you bow, you approach the podium. And then your first word, the first thing that should come out of your mouth should be,
may it please this honorable court, the counsel, so and so, for the appellant or petitioner. That should be the sentence, because from the moment you start presenting, you need to understand this fact. Your main job is to get your reliefs approved by the judges, and for that you need to please the judges in a proper professional way, not to please the judges in an unprofessional manner, but keeping the court etiquettes and manner. You need to please the judge, and pleasing the judge, by that what they mean is you need to make the court feel that you respect the court through each and every gesture of yours, every word of yours, and even every, look of yours, as in the eye contact should be maintained with the judge, and you shouldn't be shouting at the judge, and a lot many things. I will explain this in detail. So once you start with this, how to lead your arguments in front of the judges. That's what is the central theme is about. You should be having a clear and a persuasive style. Why I am asking you to have a persuasive style? Because that's what indeed you are supposed to do, not just in a moot court, but also when you step into the role of an advocate. Once you are in that robes, you are supposed to persuade the judge through your legal articulative skill, by arranging your arguments, by making the judge feel that the particular facts are in favor of your version, and without twisting the facts in an unruly manner, but at the same time leading your arguments with the strongest point. So what happens is, once you have your transcript ready, once you have already followed those steps that I have already mentioned, maintaining the central theme, having a blueprint of all these things, these will let you, in fact, do a good round of presentation before the judges. And to conclude, when you come to the conclusion, generally the second speaker does the prayer. It should be a clear statement. The prayer should be very clear and precise and to the point. The judges should feel that they want this. As in the first prayer, it can be that Article 32 is maintainable and this particular writ is to be issued. That much of a clarity should prevail. All right. And the second thing is, whenever you say a prayer, the whole team should stand up and you should make the judges feel that you are so polite. Even if you are an aggressive speaker, even if you lead your arguments in an aggressive way, once you say your prayer, once you conclude, you should do it in a very humble and polite manner. Don't show your aggressiveness at that point of time, because that is not going to let you get any extra marks, because where you can show your persuasiveness by through your aggressive speaking is when you present, not when you conclude with the prayer. Now, moving on to the etiquette and style, you need to know the judges are the masters of the court. They are generally addressed as the masters of the court. So you need to follow the court manners. And through court manners, there are a lot many things that you need to take care of. It's not just about being polite and, sticking on to the dress code and all that. More than that, there are a lot many things. For example, the way you address the judges, it matters. You might have to address a judge as a lordship, my lord, or anyway in that manner, maybe even your honor, when you, casually when you answer something. But whatever it be, every time you address a judge, that should make the judge feel that you owe and you keep that respect towards the court in complete manner. And you should always take care of your hand gestures and, podium etiquettes. As in, you shouldn't point fingers at the judge. Even if whatever the judge might ask you will, keep on frustrating or irritating you, you shouldn't point fingers at judge, because that's not how you're supposed to do. The judges, the Indian Evidence Act itself says there's a section. If anyone could, give that section in the chat box, I will be happy to see that. Anyways, there's a section in Indian Evidence Act which says that the judges are at liberty to ask any questions, whether relevant or irrelevant. The section says very clearly about that. So when it comes to moot court, I guess more than in the real courts, it's in the moot courts they ask the irrelevant questions. At least you may feel that those are irrelevant. And there are high chances also the questions are irrelevant. But I would say the main purpose of a judge asking those questions is not just to irritate you, but to prove the point that every time within the limits. He or she will be able to answer the queries, even if they don't like the question, even if they get frustrated, by not violating any of the code manners. But at the same time, you also let the judge feel that the council is having a exchange of ideas with the judges and not reacting to that particular question. As in, what I mean through exchange of ideas is this is something that you need to be very much careful about. See, the presentation should never be like a reading a speech to them. It shouldn't be like a seminar presentation. What you need to do is you need to have a conversation with the judge. All right. So more than a lecture, it's just a conversation, the exchange of ideas. And while you exchange ideas, the judges may not like some of your ideas. They will interrupt you. And when they interrupt you, you shouldn't be, feeling all of a sudden, agitated, and you shouldn't behave in a rude manner. That's why being polite, and even at the same time, if disagree with something, you can definitely disagree by following the respectful disagreement ways, as in saying that your lordship, I don't agree with the same, but I do consider why the lordship might have put forward it to in such a manner. That is the way in which you can deal with the questions. And now, when I say the judge is the master of the code, always avoid these things, as in being too formal or too casual, or even not listening to the questions carefully, giving an answer without thinking, failing to address the concerns raised by judges. I will explain these things in detail. And yes, rehearse, and rehearse. That's okay. Fine. The time being, the rest is yes. Let me tell you. You can see me, right? And I guess you can hear me also clearly.
Someone, please, if you could answer.
Yes, sir. You're audible.
Yeah. So the point is, see, I just thought if I'm more than having a PPT presentation, I'll just explain it to you as to what are the things that you need to take care of once you present. I just thought I will give it to you in a direct more than through a PPT. See, as I already mentioned, you need to have a conversation mode of arguments before the judges. But that conversation, it should be an exchange of ideas well within the code etiquettes. And when I say that, I always already told you that don't read a speech to them. They are not waiting there or sitting there to hear, whatever you might have written down in your memorials. They can easily go through that memorials. They have a copy of your memorials. So that's not what is expected out of you. What they need is to convince them, to convey your ideas and convince them as to why you are arguing this particular contention for your client. So that's what you need to do. And always remember this when you say this, the judge may ask you any questions. He or she may interrupt you while you're presenting. Don't get agitated. Furthermore, once the judge asks you a question, even if you are in the middle of a sentence, stop right there. Hear the whole question. You may feel that the question is irrelevant. You may feel that the judge is trying to, persuade you to go out of your track. You may feel a number of things. But what you need to do is, you need to make sure that you don't bluff. If you don't answer for that question, you don't know the answer for that question, never bluff. Tell it blatantly, but in a polite way, that your lordship, the council is unaware of the same. And don't say it in a manner as if the judge will feel that you are being rude, as in, I don't know. Don't say an I don't know in front of a judge. And you always remember this, even though you are in your first year of LLB, you might be arguing that moot court proposition in front of the Supreme Court. So consider yourself lucky enough to step into the shoes of a Supreme Court lawyer and to present in front of a judge. Even if you didn't consider yourself to be lucky enough to step into the shoes of a Supreme Court lawyer, the judge will definitely not let you show disrespect to him or her. I never let the councils do that. I will, as a judge, I used to ask them a number of questions. I love grilling the mooters, provided my grilling is directly proportional to the level of your presentation. If you are very good prepared and if you are well versed in your arguments, then I will grill you like anything. I will take you to any number of things. As I mentioned yesterday, as an answer to one of the queries, that what is expected out of you is to present the case well within the limits, within the time limit allowed. But even if the judge is trying to dissuade you or persuade you to go out of the track, to let that not happen in a very polite way and to get the judge back to the track. That's what you need to know. So in order to do that, what you need to understand is you need to focus on the fact as to why you are right rather than why the opposite side is wrong. So that's something you need to prove, that why you are right in arguing that contention and not why the opposite side might be wrong, because you will also argue for them once you step into the shoes of the respondent. So what you need to know is you need to maintain your standards well within the structured argument limits, remain ethical at times, and you need to stick on to the important authorities or citations, whatever you might have for your help, and you need to create a unifying theme out of all these arguments, like the factual, legal, and combining it together, and then present. So one thing that you should be aware about is the judges are not sitting there, not supposed to sit there idle and hear all your arguments, and say that yes, okay, fine, we finally agree. That's not the quality of a good judge, is what I believe. They are there to judge you. They are there to ask you those questions the opposite side wants to get redressed upon. So be prepared for that questions. As in, once I said that you need to practice, practice, and practice with your transcript. What I mean is, you need to step into the shoes of a judge and think as to what are the possible questions that may come out of this particular contention, or what are the possible issues that may be raised, or how can my arguments be defended upon. Now, while you prepare for both the sides, this actually helps you, because when you present for the petitioner or the appellant, you have the respondent's memorial, you have the respondent's points with you, as you might have also prepared the memorial for that side also. So you know how the respondent or the petitioner will be countering this particular argument. So you need to expect those questions to come out of the judges. As in, my point is, if you're presenting the appellant, you be aware about this fact that the judges at that time will be completely sitting in favor of the respondent, because the questions they ask at that time most probably will be supporting the contentions of the respondents. But that doesn't necessarily mean the judge is biased, provided if the same judge is grilling the respondent also in the same way, so to make you feel that the judge supports the contentions of the petitioners at that time, then the judge is not biased. And rather more, even if the judge is biased or not, that's not going to depend upon how you present. See, your presentation is the thing in your hands and not how the judge is going to ask you questions. So you need to be very much thorough about what you present, and you need to anticipate the questions at least to a moderate level of difficulty, if you couldn't even go beyond the limits. And for the same, I would say you need to be thorough about everything, every legal and factual provisions regarding the contention that you might be arguing. For example, if you are arguing Article 32, then you are also supposed to know about Article 226. You are supposed to know about the difference between Article 32 and 226. You are also supposed to know about which particular writ jurisdiction, whether it's the writ jurisdiction of the Supreme Court or the writ jurisdiction of the High Court, which holds wider powers. And you also need to know the nuances related to that. At the same time, the judge may even ask a question out of Article 136, all of a sudden. The judge will also ask you questions about the various jurisdictions of the Supreme Court. That time you can't rely upon saying that, this is irrelevant. The judge may ask that because this is something very basic that you might have to know once you argue under Article 32. Because when you argue under Article 32, that comes around, under one of the jurisdictions of the Supreme Court. So it's quite natural for the judge to ask you questions about the other jurisdictions of the Supreme Court. It can be from the original jurisdiction, advisory jurisdiction, which article deals with that, whether the president, even if he takes an advices from the Supreme Court, whether it is binding upon him. So any questions of that sort. So to understand that thing, you need to have a clear-cut idea about legal provisions that may be connected to the contention that you are going to use. Why I am saying you this is, have seen teams with the worst level of preparation when they were arguing for Article 14, and when I asked them, what do you mean by twin test? Say, twin test is the basic principle behind Article 14. It's about having a rational nexus and an intelligible differentia in classifying a statute or a law. And the council was staring upon me as if I just asked something, highly unparliamentary or something. So I went by my own rules. I turned to the researcher and said, every question that's not answered by the speaker will have to be answered by the researcher. The points will be cut if the answers are not given. All right. So the second speaker came in. So she was going to present in 19 and 21. But I had this question: what do you mean by twin test? So her answer was, Lordship, that's not the contention the speaker is dealing with. It has been dealt with by my co-speaker. So I don't know the answer for that. Really, really. What do you think of that situation? The judge is going to get convinced by that, all because of the reason that that speaker might not be arguing Article 14. It's not guaranteeing him or her with the right to say that he or she is not supposed to know what is twin test in the Article 14, because you are representing that client as a team. You might be arguing the other two contentions which your co-speaker might not have dealt with, but that doesn't necessarily mean that you are not supposed to be aware about that. You need to be aware about that. I'm telling you, there is no, compulsion upon you to know everything under the sky, each and every law in the country. Nothing of that sort is what I'm trying to convey. What I'm trying to tell is, when you're presenting a mood, even if you are not supposed to present the first two arguments or contentions, you need to be aware about the legal position at least. Maybe you will not be knowing as to how the factual situation is connected to that legal provision, because that's what your co-speaker is supposed to argue and convince. But you need to know the law. This should be there. This is what I was trying to say through reading the important authorities and following them. You have to convey what you need to say. And one more thing is, I would say it's always good to memorize your, opening and the roadmap. At least that much. I'm a person not good at rote learning. I'm not good at memorizing things a lot. But still, I at least, my kind of understanding is I understand something and I put forward the same in my own words. I can't rote learn and reproduce. If you're good at this, you go for that. If you're not good at this, then find out your own methodology in which you can, give your opening and put forward the roadmap before the judges without even, letting the judge feel that, you are having some confusions or some fumblings over there. You should be confident. I'm telling you, every time you present, you should be confident, irrespective of the language barrier that you have. You might have your problems with your accent, you might have problems with your enunciation, but you might be confident at the very same time, because the judges value the knowledge that you have regarding the mood problem and the research that you conducted regarding the legal provisions more than your language. Definitely, language is one criteria, but that is not the sole criteria, is what I'm trying to say. All right. So don't think that if you're not a good speaker, if you're not good at English, if you have issues with the grammar or something, and not confident enough to speak in a proper way, that's not the end of your mooting career. Never at all. Never think like that. I have seen people, even the judges do support such speakers. If the judges get to feel that they know the law, they know the provision, they are good enough to, you know, argue, then you need to do that. And I will say, you know, there occurs at times, the judge shows some kind of generosity to you. Maybe because the judge feels that your side is weak, as in the problem is weak, the factual problem is not supporting your side, something of that sort. Okay. Even if it happens in a very less number of cases, but even if it happens, never take advantage of that, because the same judge can go against you in a single moment once he gets the feel that you are going by the flow that the judge offered and that you are not having anything from your side. Okay. So it's all about having, you might be thinking right now, because every time I say something here, I'm repeating the word judges, judges, judges again and again, because it's the judges. It's the judges. It's the judges. They are the masters of the court, and they are going to determine your presentation. They are going to determine how much you know. Maybe you know about the problem and the law more than them, but that doesn't matter. What matters is how you present it and how you articulate your provisions, and how you persuade the judge to uh, come to your conclusion and your prayer. So In order to do that, you need to give a lot much of respect to the judges. And how you show respect, apart from all other things that I mentioned till now, you need to do a couple of other things also. Always take care of this. When your judge asks you a question, be very much careful before you answer. Maybe you will start to get a feel once he starts the question, and once the judge reaches the middle of the question, you might be getting a feel that yes, I know the answer for this, and you might be wanting to answer it very fastly. Don't do that. Always wait till the judge ends the question. I'm telling it to you because if you jump into the question, it may go against you. Because what happened is, I remember one time I was judging a moot. It was on a law of crimes, and this guy who was he was a very good presenter, but he was every single time I was putting forward a question, as he knew the answers, he was like jumping into the questions, and he was trying to finish at that moment. Even before I finished the question, he wanted to finish his answer. So once what I did is like I expected him to do the same. He did it, and I changed the question all of a sudden. And what happened is he was taken aback. He never expected that question. I changed the flow of the question. I was trying to have a question in a different angle, and I went against the flow. I completely turned it around. And his answer was not at all satisfying. He all of a sudden, got stuck. His arguments fell apart. And no, it took him some time to come back to the arguments. So don't do that. What happens is, when a judge is trying to ask you questions, if you jump into that, even if you are confident or maybe overconfident, the judge will feel that you are trying to intrude into the judge space. Definitely that will affect your marks, because the judge will not be happy with that, and he can take the question from that level to a difficult level where at least you may be able to answer, but you may not be able to convince, because the judge has already become prejudiced against you. So never ever agitate the judge. Second thing is, don't give an answer without thinking. Even if you know the answer, before you answer, just ensure that you got a thought process running behind the brains before you answer that. Because if your answer is failing to address the concerns raised by the judges, you are again going to lose time, and you will again have to face the number of sub queries and queries coming after one after another before you take the judge back to your argument track, and that will result in losing the time. So what you can do is, you need to rehearse, I would say, n number of times, present it before n number of people, get the maximum number of questions. As in, one methodology that I was following when I was a motorist, for every single time I was prepared with the memorial, I started my oral presentations. I always had a first round of presentation for almost all the good faculties that I felt like in front of the in the college. And after that, what I do is, like, after the first round of presentation, I always ensure that my researcher is there to take down all the questions with me, because I will not be able to take down the questions and listen to it, think, process, answer, and everything. So once the first round is over, the team will be having an idea as to which are the judges who had actually contributed to us by asking good questions. Okay, by challenging our limits. So we used to go to them again. All right. And I'm telling you, there was one of the professor in my college. He happened to be a practicing lawyer for quite long period before he came to the academics. So his kind of questioning was, very much different from the people in the academics. He used to ask those practical questions, which generally we used to be put in before the court. So every single time I presented before him during the first rounds, he used to make me feel so dejected. I feel, I come out of the class feeling that no, I don't have answers for anything. But once I get more and more answers, once I get more and more confident, I used to face his questions in a more easy way. How it helped me is, once I went to the rounds, even before I stepped in for the preliminary rounds, I might have already presented at least 15 to 20 times before different, kinds of judges. One aggressive, one very moderate, one very calm, and I have faced maybe hundreds of questions. So I'm not anymore having any confidence issues. Rather more, I will be able to anticipate most of the questions, considering how the judges are going with their flow. All right. So this is something that you need to follow. Rehearse, and keep on re-rehearsing again. And always remember, it needs to be a conversation with the judge rather than it be a lecture to the judge. Never ever read it out from your argument notes or from your memorial once you approach the podium. Because what it feels is, to the judge, it feels just like a seminar presentation that you might give in your law colleges. That's not what the judge is expecting. Always maintain an eye contact. If possible, try to keep a smile. And even if the judge is grilling you like anything, don't show that frustration in your face as if that you want to kill the judge. Even if you want to kill the judge, don't show that frustration in your face. Try to maintain a smile. Even if you couldn't maintain a smile, don't give him a feel that you are agitated and or don't give him a feel that you are dejected, because it all counts. The judge watches all these things because in the judging criteria, what they have is around 10 to 15 points. It depends upon the law colleges, but generally they do have around 10 criteria. And it also reads about your, one of the criteria being about your body language, how you express, how you respond when you are being questioned. All right. So it's not just about articulative and the persuasive skills, but it's also about the body language that you show. And on the other side, I'm telling you from my own personal experience. See, once I went to litigation after completing my graduation, what I felt is the moot court career for the 5 years in my law college, it helped me a lot. It helped me a lot in such a way that I was never ever afraid to face the judges. Even if the judges are asking questions, we will not be afraid to answer. And let me be honest when I tell this. The judges in real courts, they don't ask that much of questions as in what happens in the moot courts. They don't do that. Okay, not every judge. Once in a while, you get maybe a judge or a couple of them who will be grilling you like anything. But other than that, most of the judges, they don't even ask questions. They may ask if relevant, but they may not waste their time because they got a lot of work to do. Not like a moot court judge. No, that moot court judge is there just to grill you, so he or she will be keeping on doing that. That's not how it goes in a law court. So my point is, enjoy the mooting, enjoy the grilling in the mooting sessions, because that's going to finally let you have your own successful career in litigation once you step into the robes of an advocate and present before the honorable courts of law. And I will tell you one more thing. Consider yourself lucky every single time you get to present before a moot court judge, because you might be presenting most of the moot courts nowadays. I get to see a problems relating to family law or local courts very rarely. But other than that, most of the moot court problems, you know give you a presumption that you are presenting before the honorable apex court or high court. In the case of international moot court, it will be in the ICJ or ICC. So just consider yourself lucky enough to do that. Okay. And it's all because of the reason that most of us are not going to present before all these courts anytime during the whole career. Even if you are in litigation, you may get yourself limited to some particular areas, and you can't expect every single one of the mooters who are presenting right now to go to all these courts, from the high court, supreme court, ICJ, ICC, no. So every single time you get a chance to present before these judges, take that seriousness inside your mind. Just consider yourself that you are representing that particular client in the ICC or ICG or Apex Court, wherever it is, and show that seriousness while you present. And I assure you one thing: once you do all these things, it will help your mooting career to grow in a successful way, and it will definitely let you have a um, lot amount of confidence once you step into the roles of an advocate and wear these robes and go to the court. So I guess that's all the presentation. If you got anything else to say or ask, you can definitely do that. I'm more than happy to answer. Thank you. Unlike yesterday, they don't have any questions. So Anika, is it like that we can wind up? They don't have any.
So, yes, so there's a question. So, you will read the question or should I?
Yeah, sir, how do we address a judge of different courts, as in your lordship for Supreme Court? See, in normal, almost all the national moot courts, what we do is we address the judges like your lordship or my lord. And during the round of presentation, sometimes you may be answering in a hurry, and your honor will be the way you can address. Anyways, following Milord or your lordship is generally advisable, and you can depend upon addressing the court with your honor, not just when you start with the arguments, but during the time of your presentation. That's going to take care of. When once it comes to the international moot courts, for in the case of ICJ, of the rules are being followed as in the ICJ presentation, International Court of Justice. What they do is they have the president and the members. So generally, what they do is they either address the court as the president or Your Excellency, and the members also as Your Excellency. Sir, how to manage the time as in finishing all your arguments and prayer when a judge is asking a lot of questions? Yes, this is why I told you to have a supplementary transcript. See, the judges will keep on asking questions. I am a judge who used to ask a lot many questions. I'm generally in my court. It's not the mooters who used to take a lot of extra time. It's me taking the extra time, allotting them because I want to ask more questions. But at what happens is uh, I will be more interested in getting answers out of them. I will be, not in a position to think that they need to finish this. It's not my responsibility for them to finish. It's their responsibility. So what you need to do is you need to keep that thing in your mind. That's why I asked you to practice as many times as possible. With consistent practice, what happens is you know how much time you need to prepare, present, and convince the judge if the judge is not interrupting at all. And also, once you practice by presenting before a lot many people, you also get to know that particular time which you need when you need to answer, depending upon the level of questions, easy, moderate, and difficult, as to how many extra minutes that you need. So based on the same, you can plan your arguments. I'm telling you, never depend upon the arguments advanced in your memorials. Never think that you are going to read it from the memorial in front of the court. First of all, it doesn't give you a good impression before the judge. Second, you will never be able to finish all the contentions. Think of this. You might be having your arguments advanced written for around, 15-20 pages. Okay, divided into 4 contentions, 2 contentions each for each speakers. The bare reading without any interruption from the side of the judges, the bare reading of all these pages itself will take around 20-30 minutes. Then how do you think that you are going to substantiate your contention? That's why I'm telling you, never depend upon the arguments advanced in the memorial. Always make sure that you have a transcript from your side, because you need to, as I already mentioned, you need to cut down your points. You need to hierarchically organize your points and lead with the strongest point. Never keep yourself reserved with the strongest point, so that once the judge asks, I will answer. Maybe if the judge doesn't ask, what happens? You lead the no, you miss the chance. So always lead with the strongest point. But that's why I told you maximum 3 to 5 points, factual points is going to be helpful enough to save your side, to prove your contention. Do that. You'll be able to do that in a considerable amount of time. So with practice, rehearsing, it will be beneficial for you.
So there are no questions in the chat box. Do you have some questions? So there's one question.
What are the general distinctions, normal mooting and trial advocacy? It's different. See, in trial advocacy, it almost follows the pattern of what happens in a court. It's very different. In trial advocacy, what happens is you have, for example, if the trial advocacy competition is giving you a problem on murder, they will provide you the witness statements, the charge sheet, the FIR, the MO objects list, and everything. Okay. So what you need to do in the trial advocacy is you need to study each and everything. You need to be prepared for 3 levels of questioning. One is chief examination for your own clients, as you will be representing either the prosecution or the defense. And the second, the cross examination of the opposite side. For example, if you are the prosecution, then you need to cross examine the accused. You need to convince the judges in that rounds using the documents that you have from the trial advocacy proposition. And the documents, by that I mean all the witness statements, the FIR, charge sheet, MO, object list, and if you got any forensic report, everything, just like in a court of law. That's how you deal with a trial advocacy. It's highly different from a mooting competition. In mooting, what happens is you just get a limited set of facts. Maybe the facts will differ from 1 page to 15 page. That is only difference going to have. Then you prepare a memorial. You divide the issues. You find out you research on these issues, find out the law, and then you come out with the arguments. That's what you do in mooting. But in trial advocacy, it differs. There, even you even get the chance to cross-examine the witness, and cross-examination is an art, I should say, because it's not where you can pre-prepare your questions and ask in a random way. Because in cross-examination, what happens is you ask a question to the witness. It can be the accused, it can be the prosecution witness or the defense witness. All right, if I am the prosecution, my cross-examination will be to the defense witnesses as well as the accused. So accused. And what happens is I ask a question presuming that he or she should be giving this answer. Okay. And if he or she doesn't give that answer, I should also be prepared to counter that answer with a different question which supports my case. Okay, I should not be contradicting my own case, because every single question that you ask, it's not about the number of questions that you put forward in the cross-examination which matters. It is the quality of questions which you put forward. The least number of questions in a cross-examination will help you save the case. It's not mandatory to have the maximum number of questions. So that's a different scenario when compared to mooting. Sir, is it mandate to
So,
use only those points which we wrote in our... Yes, Anika?
so I was saying that should I read the question or it is okay with you to read the question?
No, that's okay. No problem. I can read it. It's
Thank you, sir.
mandate to use only those points which we wrote in our memorials. Like, can we add up anything new during arguments? Definitely. You can definitely add up new points. And rather more, I will tell you one thing. What I used to follow when once I reached my third or fourth year of LLB study, by that I had a considerable experience in doing mooting. And what I did is I never ever revealed my best points in the memorials, especially in those competitions when there's memorial exchange, because everything will get to see what are your points. They will get to see either the petitioner or the respondent. All right, I always reserved my strongest lead argument in my argument notes and never revealed it in the arguments advance. As in, I will not be directly commenting upon the same and writing elaborately on that in the arguments advance, but I will be briefly mentioning or at least just mentioning about it. But I will not let the person who read the memorial get a feel that that is going to be my strongest argument. I will let them know that that point is there along with certain others, but I will not reveal that that is going to be the best argument. And rather more in times what happens is you submit the memorial and then you get to find out some new information regarding that particular contention. Definitely you can make use of that in the oral presentation. No judge is going to let you know stop you from presenting that, except some sadist judges. They did, no, not just sadist, but yeah, I have seen some judges saying that you can't argue anything other than in the whatever is written in the memorials. But generally the judges don't do that. You are free to do that. Now, next is, sir, if I am already running out of time, so just keep pressing them. How do I deal with it then? And how do I jump to prior in order to avoid the risk of not? All right. What you do is, first of all, the allotting of time is all upon the discretion of the judges. So every time you feel that you are running out of time, you need to humbly remind the judge and humbly ask the judge for extension of time, saying that, my lord, if an extra time may kindly be allowed to the judge, council. The council will finish it in another couple of minutes. You can use any of those extensions. Whatever it is, you just need to make sure that you put forward it to the judges in a very humble way. Generally, they do allow it. Otherwise, they don't. Even if they don't, what you need to do is, if they said no, go to your prayers, then go to your prayers. That's what I would say. When I say to a council that council, I'm done with your arguments, move to the prayers, it means I am not interested in hearing the arguments. Maybe because I have already convinced myself about their arguments or not. It's not going to happen. Whatever it be, once the judge says they are not going to give you extra time and move on to the prayers, move on to the prayers. Okay. Never argue with the judge, because that doesn't, mandatorily get you an extra mark, and most probably it will result in the opposite team gaining an extra mark over there. So what type of questions are asked in the researcher's test? All right, researcher's test, I would say, generally, anything can be asked regarding the moot court proposition. It can be factual questions, but generally they do limit themselves to the legal questions. So, and the important thing that the researcher need to notice is the questions can come from all the contentions and from both the sides. As in, for example, say it will not be like a grilling session, just like in the oral presentation of mooters, but still the questions will definitely vary from the first contention to the last contention, or even more than that. And as I already mentioned, even if the contention is just dealing with Article 32, they will ask what are the different jurisdictions of the Supreme Court. How is it different from Article 32, different from 226? Why is SLP not preferred here? As in, what is a special petition? Why is it not preferred here? So, what are the fundamental rights that can be protected through 32, which are not available to 226? Like the same number of questions. So basically, it's all about the moot proposition and any law related to that. You need to be prepared about that. Okay, I guess that's all.
Okay, so are there any questions in your chat box? Can you just check once.
No, I can't see any Anika. These are the
Okay.
ones here.
Okay, so no problem. So now here we are towards the end of the session as there are no more questions. So now I would like to invite Miss Avantika to present a vote of thanks.
Thank you so much, Anika. Anika, can you please tell whether I'm audible?
Yes, sure.
Thank you so much, Anika. So, after the successful completion of the 2-day national workshop in Art of Memorial Drafting and Skills of Argument in Moot Court, I would like to take this opportunity to render my vote of thanks. First of all, I would like to thank the instructor, Advocate R.S. Viruth, sir. Thank you so much, sir, for all your valuable time and your efforts. I would next like to thank the participants for the active participation and their cooperativeness. Thank you so much, participants, for joining us. Lastly, I would like to thank the team of the Amikus Qriae for making this event such a successful one. And I would like to render the last vote of thanks, especially to Kalpesh Gupta sir, for all the contribution that is made in this session. Thank you so much, everyone. Thank you, Anika.
Thank you, Avantika. Thank you, sir. I hope we'll